We have the case Alexander S. versus Des Moines Public School District in Heartland, AEA 11. Here's some background information of the case. Lisa S. and Michael S. had 4 children together. Alex is the youngest, only child with special needs. In the fall of 2005, Lisa and Michael separated. Lisa S. moved to the East Coast. The divorce was final in February 2007. Michael S. had physical custody during the separation. Both had joint legal custody. Michael retains primary physical custody of all children. Lisa S. had scheduled visitation in the summer, during Christmas vacation, and spring break. Lisa S. was Alex's primary caretaker before leaving Iowa in 2005. Lisa also did not have visitation or contact with Alex until June of 2008. Facts of the case. November of 1999, Alex suffered a brain injury. The incident was intraceable. Seizures. Origin is unknown. Substantial defects in learning, adaptive functioning, and communication. He also exhibits challenging behaviors. Lisa came back to Iowa, Des Moines, and filed a due process complaint in December 2010. She wanted full access to educational records and challenged Alex's placement. The initial complaint was resolved by a new IEP for Alex. The Des Moines Public Schools wanted Alex to attend Ruby Van Meter, which is a school for severely kids with severe mental and cognitive disabilities. June 2011, all IEP members agreed that Alex should be transferred to Ruby Van Meter. It's a special education day school. Miss S. Lisa did not agree with this decision. She wanted her son to go to Merrill Middle School, his home school. Proposed placement violates the least restrictive environment provision of the IEDA. This is what Miss S. told the Des Moines Public Schools in Heartland, AEA. She also commented that the placement procedure was flawed, that there was no general education teacher on the IEP team. Ms. S. felt that she was denied meaningful participation in the IEP development process. IEP team did not consider evaluations from Dartmouth Medical Center. Ms. S. had took Alex to Dartmouth and had evaluation, and that wasn't considered in the IEP meetings or in a decision to send him to Ruby Van Meter. She offered videos of Alex as evidence during her visitation. However, it was rejected at the time, or objected, at the time, because it should have been presented 5 days prior, and I believe it was only presented 2 days prior. But objection was sustained, and she was given the opportunity to submit the videos, but she did not. Des Moines Public Schools' response was they defended their decision to transfer Alex to Ruby Van Meter. IEP team considered past performance and current evaluations, observations offered by special education teachers and consultants familiar with Alex's functioning in and out of the classroom. Parent input was considered as well. Mr. S., Alex's father, he was on the side of the Des Moines Public Schools. He thought Alex should be transferred to Ruby Van Meter because he believed that Ruby Van Meter could help. Did consider several placement options, including Merrill Middle School. Cognitive limitations social and emotional skill defects prohibit Alex to be in a middle school setting, according to Des Moines Public Schools and Heartland AEA. Ruby Van Meter was the least restrictive environment appropriate placement for Alex, according to Des Moines Public Schools. Des Moines Public Schools also offered that Miss S did not properly raise her procedural challenges. Even if raised, they would have failed. Mr. S strongly supports the district's decision, like I mentioned earlier. Applicable laws to the case. Least restrictive environment, Iowa Administration Rules of Special Education 281-4.1142B. Placements. This is the one I'm gonna be specific on. Under Iowa Administrative Rules of Special Education 281-41.1161, and I'm gonna go down to C. Unless the IEP of a child with a disability requires some other arrangement, the child shall be educated in the school that he or she would attend if non-disabled. Also E. A child with a disability shall not be removed from education in age-appropriate regular classrooms solely because of needed modifications in general education curriculum. The final decision was to send Alex to Ruby Van Meter by the school board or by Des Moines Public Schools and IEP team. My personal response, I'm going to backtrack a little bit, but Mr. S had been the primary caretaker for Alex since the divorce. Miss S has attended all the IEP meetings. I'm sorry, Mr. S has attended all the IEP meetings for Alex. One of my questions is, why did Miss S leave and not have visitation for almost 3 years? Why did Miss S come back and fight against everything that Mr. S had done with or for Alex? Miss S wanted to keep Alex in his neighborhood school. Why? After going through all that information and going through the case, I believe that Alex should have had the chance to attend Merrill Middle School. For this reason, Iowa Administrative Rules of Special Education 281-41.1161C and E, the ones I just read on the previous slide. Accommodations could have been made for Alex to attend Merrill Middle School. I believe that the district should have taken a closer look at what's best for the child. What are the implications? IEP teams really need to communicate with parents about everything that is happening with their child within the school. Making multiple attempts to get parents to IEP meetings. I've been a part of a few IEP meetings in school, and not every parent shows up, but documenting and making sure that those kids or that the parents are well aware that we're having a meeting. So on this date, 3 or 4 reminders, and if they don't show up, it's all documented. General education teachers really need to document everything that happens within their classroom with the student on an IEP, just to ensure correct data is being taken. This right here will change my teaching practices, making sure that I know in each of my classes which students are on an IEP, and being able to document behavior and what they're learning, and just spending more time on doing that. IEP teams really need to make input. Sorry, let me rephrase that. IEP teams really need to make decisions that are best for the student and heavily consider parent input. In this case, and this made the decision a little bit harder, the 2 parents weren't on the same page. One wanted Alex to go to Ruby Van Meter. The other wanted him to stay at his home school. Mr. S kind of reminded me of myself and my situation. I have a son on an IEP, so I can empathize with what he's gone through, all the meetings, the decisions. However, I still think that Alex should have the opportunity to go to Merrill Middle School. Teachers should not rush to make decisions or have personal feelings against certain students on an IEP. And I know certain students can rub us the wrong way sometimes, but we still have to be professional and do what's best for the child. Making sure all data is correct and leave no rock and turn when recommending a different place for a student. I don't think Des Moines Public Schools and Heartland AEA did that in this case, and I could be wrong, but from reading the case, I don't think they did that. I think they made a rush decision without considering everything, or giving Alex a chance to go to Merrill and basically trying to prove himself. Questions. Number one, how would you feel if you were Mr. S and your former spouse came back and basically went against everything you had been doing for your child? 2, based on the information provided, what do you think is best for Alex? And number 3, what is your opinion of the DMPS decision? Thank you.